Good morning, council. You both will have 15 minutes to present your arguments, and the appellant may reserve up to 5 minutes if you so choose.
Good morning, Your Honors. May it please the court, I am Assistant Prosecuting Attorney Leslie Walter, representing the appellant, Summit County Public Health, which I may, just for shorthand, refer to as the district. And I would like to reserve 5 minutes for rebuttal.
Thank you.
The essence of the appeal today that we are taking is with respect to the issue of abuse of discretion. What was the Common Pleas Court supposed to do when it reviewed this administrative appeal? And did it take any action which was unreasonable or clearly wrong? When Revised Code 119.12 was revised into its current version, which now appears to be over 50 years ago, it gave Common Pleas Courts increased authority to conduct a review of the evidence itself, but this is a limited authority. This has been discussed to a limited extent by the Ohio Supreme Court in case law, including Andrews from 1955 and University of Cincinnati versus Conrad in 1980. The essence of these cases is that there is this limited ability to review the evidence where there are legally significant reasons to discredit the evidence and where it is also necessary to the court's determination to do so. This is a key point that is being emphasized by Mr. Eckert in his brief, but we would submit that the analysis is a bit more complicated as illustrated by subsequent case law, including some decisions decided by this district. When a Common Pleas Court is reviewing the record, for example, Revised Code 119.12 does say that the court is supposed to review the agency's order to determine whether it is supported by reliable, probative, and substantial evidence and is in accordance with law. So one would expect that in the Common Pleas Court's decision there would be reference to the agency's order. In this instance, we will see that that is not the case. In addition, as far as case law is concerned, certain limits as to what can be addressed in terms of reviewing the evidence from the record are illustrated. The first example I'd like to look at is a case from this district called Steiner versus City of Akron, decided in 2000. That administrative appeal involved a threatened assault between two co-workers working for the City of Akron, and it was more or less a he said, she said scenario. And in that instance, the employee who was threatened was deemed to be more credible than the employee who was accused of doing the threatening. The Common Pleas Court did not alter that decision and affirmed the accused employee's removal. In that instance, a principle was illustrated, which was when there is conflicting testimony of equal weight, deference shall be given to the administrative body, and that was done in this instance. Let's look at another example of case law that helps illustrate what is appropriate for a Common Pleas Court to do. In the case of NR Inc. versus Ohio Liquor Control Commission, again cited in my brief, this district held that where a liquor establishment was serving alcohol after hours, the testimony of a police officer who was considered a disinterested witness was given more weight than people who were inside the bar establishment and testified that there was no liquor being served after hours. The police officer testified that he looked through a window, saw what appeared to be beer being served, and testified that it was 2:45 a.m., well after the 2:30 a.m. deadline. That testimony was given more weight, and therefore the liquor establishment was deemed to be in violation of its license. What the Common Pleas Court did was said, here is evidence that we determine to be more credible because that person is disinterested. In another instance, in Carter versus State Board of Education, this case is a 10th District case from 2011, hearsay evidence was determined to be of less weight than direct testimony. In this instance, a teacher was accused of sexually assaulting a student. The student did not provide direct testimony. Instead, the student's mother, father, and his psychologist provided hearsay testimony of what the student experienced. On the other hand, the accused teacher, who was facing the loss of his teaching license, provided direct testimony in contradiction to the hearsay testimony. The 10th District held that it was appropriate for the Common Pleas Court to give more weight in this instance to the direct testimony over the hearsay testimony. Another instance of appropriate common pleas weighing of the facts occurred in the case of Smith versus Richfield Township, decided by this district in 2012. In essence, in this case, the individual concerned was accused of running a business when his property was zoned residential. Hearsay reports were used as the foundation for the case, and also pictures were taken of his activities. He objected that a zoning violation was founded upon these facts, and the court concluded that hearsay could be used to form the conclusions that resulted in the zoning violation in that instance.
Remind me, how many witnesses were actually live at the hearing in Columbus?
I think we had, in the hearing at Columbus itself, and I would submit that all the witnesses did submit live testimony, some of it by video recording because of the limited time the court in Columbus did have to view the witnesses, but I'm going to count you.
But you would agree that somebody reviewing a videotape, you don't necessarily have to give the same deference as live testimony in the respect that the way the courts view live testimony is that the trier of fact is there actually seeing and viewing the mannerisms and so forth. So if it's videotape, that's the same as
I absolutely
or anybody can review.
I absolutely agree with that point, and I would add to that what essentially happened with the court in Columbus was that they viewed that taped testimony as live testimony. I don't see any indication, however, in the Common Pleas Court's order that they viewed the videotaped testimony of anyone. That is not expressed.
Maybe they didn't look at it.
I don't know whether they did or not, but credibility determinations were made by the Common Pleas Court that I would submit are such that you would have thought this was an administrative law judge's review, and that the court went into vast detail looking at certain aspects of the testimony to discredit and other aspects which it found to be more credible. And interestingly, those findings seem to be entirely at odds with what the State Personnel Board of Review did. And the State Personnel Board of Review had the testimony of Robert Colley, Bob Hassenjager, Sam Rubens, I believe William Tenon. On the second day we had Amin Abdul Habib, Rahif Ferris, and all of those witnesses were right in front of the administrative law judge, and he was in the ideal position to determine whether their evidence was credible and whether there were any relevant facts that resulted in the decision that was ultimately reached by the State Personnel Board of Review. And there are also certain points that are significant in addition to Section 119.12 says that the common pleas court is supposed to look at the record as a whole. And one of the things that what is concerning to my client is that in the review of evidence as a whole, there were significant points of circumstantial evidence which were not mentioned or addressed by the common pleas court. In particular, the two incidents...
Counsel, you're starting your 5-minute rebuttal if you want to say that. It's up to you.
I'll just go into it very briefly. In particular, that the two key incidences that were litigated in this case were divided between an express warning that was made to Mr. Eckert in January 2013. Do not use this kind of language with the public. This is serious, you can't do this. There isn't even any dispute that warning was made between the parties. And yet, within a month, a new allegation is made by a completely disinterested person from Akron Children's Hospital who has no connection with Mr. Eckert or with Summit County Public Health, except that he was going on a ride-around program to see how the air quality team does its job. And he makes a comment to his superior. He doesn't even seek out Summit County Public Health, but goes to his superior and says, hey, when his superior says, well, what was that like? And he said, well, it was kind of like spending the day with a racist. And from there, we get an extremely coincidental complaint that was very similar to the one Mr. Ferris had. There's no connection between Dr. Khatib and Mr. Ferris, and yet this was not commented on by the common pleas court. This is significant circumstantial evidence. Instead, the evidence that was taken, the testimonial evidence, was all evaluated in ways that would not connect the consistencies between Summit County Public Health witnesses. Thank you.
Thank you. Morning.
May I please report? I'm pleased that you're using the captain right now.
That's fine.
I am Nancy Grimm. I represent the App.No in this case, Harry James Eckert, employee of the Summit County Public Health District. A little background on the case, you've got it in the briefs, but and there's no dispute on this. Mr. Eckert was employed for many years by the former Akron Health Department until the city and the county department merged on January 1st, 2011, when he became an employee of the Summit County Public Health District. Soon after that, in May 2011, he was assigned the position of environmental specialist as a gas dispensing facility inspector. We lay people would call that a gas station inspector. This was the first job that he had that involved interaction with the public. Gas station inspections involve essentially three parts: a review of records that the gas stations are required to maintain for the purpose of these inspections, a visual inspection of the gas dispensing equipment or gas pumps, and pressure tests which are performed by an independent, at any rate a private vendor who is hired by the gas station company. So Mr. Eckert's role in that latter part of the inspection was to observe the tests.
So he was there to ensure that the independent contractor did the testing properly.
Right, in the third part. Now it was Mr. Eckert who inspected the records at the gas station, and he did a visual inspection, but the pass-fail part of the test is the pressure testing done by the vendors. That's correct.
And it is that situation out of which the complaint arises, is that correct?
Right. Well, there were two incidents that really, after a lot of smoke and mirrors was brushed aside, that really were found to be the basis for any potential discipline. One was a complaint by a gas station owner, Waterloo Oil Company, Mr. Rahif Ferris, and this involved Mr. Ferris was particularly upset that his station failed his gas pumps failed the pressure tests, and when his vendor tried to, sometimes they will try to do a repair on the scene to improve the performance of the test so they don't have to come back and cost more money to the stations. And his equipment was in such bad shape that a piece broke during the, there was some dispute about whether it was in bad shape, but it was the vendor who was performing a repair that broke his equipment. So he was upset about that and made a complaint that initially he was angry at Mr. Eckert. He suspected that Mr. Eckert somehow was in cahoots with the vendor, which was not shown to be true. The other inspection was in February, in which a resident doctor at a doctor in training at Akron City Hospital did a ride-along as part of their public health training. And there was quite a bit of credibility issues with his testimony, but he was upset at comments that Mr. Eckert made with respect to
The doctor was upset.
The doctor was.
And later retracted some of his
Right.
statements or his position.
Yeah. There's no dispute that there were alien stickers, little sort of like highway signs, no alien stickers on the gas pumps. But Mr. Eckert's role with respect to those stickers was Exactly, yes. So in terms of legal issues in this case, I certainly agree with the attorney for the Public Health District that the primary legal question is what is the role of the common pleas court in an administrative appeal, and what is the role of this court? This court's role, of course, is to affirm the common pleas court unless there is an abuse of discretion by the common pleas court. And as Ms. Walters pointed out, in an administrative appeal, the common pleas court is quite different. The common pleas court is not to do a trial de novo, but they do a review of the evidence. And those standards are set out with some explicit guidance in the Cincinnati versus Conrad and Andrews versus Board of Liquor Control cases in 1980 and 1955. And specifically, as relevant here, the common pleas court has discretion to discredit evidence for legally sufficient reasons. All the other cases that Ms. Walter cites are cases in which courts of appeals found that the common pleas court had demonstrated legally sufficient reasons for its decision to either affirm or overturn the administrative decision. The question in this case is, did the Court of Common Pleas demonstrate? Certainly in this case, and this is the concern of the appellant, the Common Pleas Court discredited quite a bit of the evidence that was presented by the Public Health District, and in fact found that the employer did not meet its burden of proof to show that conduct occurred which justified discipline. The Common Pleas decision is quite lengthy and detailed, 28 pages, and approximately 10 of those pages are specific review of the witnesses. I think that begins at page 11. And the judge went through all of the witnesses, I believe in the order that they were presented, describes the testimony of the witnesses, and has a paragraph indicating conclusions about the application of the testimony, the credibility of the testimony, and explains why the judge drew those conclusions. That actually goes from 21, 22. Okay, up through page 23. So that's 12 pages of detailed, single-spaced review of the testimony. And in each case, the judge showed legally sufficient reasons. There's no standard, despite what Ms. Walters said, there's really no standard. A disinterested witness is always a better witness, or witnesses on the scene are always better witnesses. The question is, what are the credibility issues? Is it hearsay that's admissible? And in each case, I don't think Ms. Walters has identified any situation in which the judge's specific conclusion was not a legally sufficient reason for her evaluation of the particular evidence. In briefs, Attorney Walters has identified one document in particular that she disagrees with the judge's decision and argues that Exhibit Z should have been used to corroborate the live testimony. I have a copy of Exhibit Z here. She makes that argument because Exhibit Z was admitted at the request of my side of the case, my client. Exhibit Z is a notes recorded by the Assistant Director of Public Health, Sam Rubens. And what Ms. Walters wants the court to note is the first page and a few lines on the back of the page, which are Mr. Rubens' hearsay recording of statements made by Rahif Ferris, some of which was Mr. Ferris's explication of what he thought other witnesses would say. However, the witness was admitted based and verified. The only part of this document that was verified were the notes at the very end of Exhibit Z, in the back of the page that I'm holding here, which are Mr. Rubens' recording of his own thoughts after the interview. And the only part of this document for which the foundation was laid was Mr. Rubens' notes with respect to how this complaint, if true, would fit into the disciplinary policy, that is, that this would be a Group 1 offense. The argument that any of this evidence would be taken to other reasons would have to pass the test under the hearsay rule promulgated by the State Personnel Board of Review. It's interesting that Ms. Walters did not quote that rule. It's quoted in my brief, which says, on the one hand, yes, the board may permit introduction of evidence otherwise excludable as hearsay, but also states, a foundation establishing both the reliability of the testimony and its necessity shall be laid before hearsay may be admitted. The employer has not identified a proper foundation for any of the testimony which was excluded as hearsay by either the court or the hearing officer. So I don't know that, I think there were also arguments by Ms. Walters, and she somewhat alluded to an argument today, about the number of witnesses and that there are X number of witnesses. In most of that, she's counting hearsay statements to corroborate testimony, but it's as I'm sure you judges know from all the cases that come before you, it's not the number of witnesses, but the quality of the testimony that the court reviews. And certainly here, the judge made a very careful review of all of the witnesses and of the conflicting testimony, and looked at how those conflicts weighed, and tried to put aside the great amount of hearsay evidence and evidence that was not relevant to the issues that were properly before the State Personnel Board of Review.
And I know that the trial court recited that, what the standard is and what her standard review is and so forth, but it almost reads as if it was a de novo review, like it was an original ruling. Like you said, 28 pages, each witness. I don't know that I've ever seen 18 years as an appellate judge, that type of detail for an administrative appeal.
Well,
I'm not saying that's wrong, I'm just throwing out there to say, what is your reply to that?
I think that's important to show, one of the questions that Ms. Walters raised was, did the judge review the entire record? And if, she would be more subject to an argument that she did not review the entire record if she didn't recite all that. For example, to give a contrary example in this very case, when the State Board of Personnel Review, which is the official decision maker, reviewed the decision of the hearing officer, the State Board of Personnel Review had a 2-sentence decision. It's really highly questionable, the State Board of Personnel Review, whether they reviewed any of the evidence at all. We have no idea. Judge O'Brien made it clear that she reviewed the evidence. She bases her decision on whether it's the transcripts or looking at videos. We don't know. I would note that my own client testimony was by video because there was not time, despite we have a 2 or 3 day hearing, there were I think it was 2 days, there was not time to present his evidence because of the amount of time taken up by the department's witnesses. We did have a couple of witnesses out of order as well, but his own evidence had to come in by the later video and transcript. But I think the judge properly demonstrated her review of the evidence. There was quite a bit of hearsay, both in terms of the documents submitted and in terms of the oral evidence. So it was necessary to do that kind of detailed review in order to demonstrate an appropriate decision. But again, the question here is, did she show legally sufficient reasons for her decisions? And she did in each case, in each example. In fact, not a single example has been shown. We have the general, it's so thorough, it has to be a de novo review. On the other hand, maybe it's not thorough enough. I haven't seen any, I've never heard of any evidence that she didn't review. She certainly made decisions about what evidence was really relevant to the issues properly before the Court of Common Pleas. And I would note one thing that happened in the hearing, and when
you need to wrap up.
I'm sorry.
That's okay.
Okay. I'll just note in terms of what was properly before the court, this is an appeal from a State Personnel Board of Review, and prior to coming to State Board of Personnel Review, there was a decision by the employer, and after a preliminary pre-disciplinary hearing. So not all of the evidence that the employer submitted to the pre-disciplinary hearing was found to be just cause for discipline by their own internal hearing officer. Nevertheless, a lot of that evidence was resubmitted in the State Personnel Board of Review, so that was one reason there's a lot of extra stuff. Thank you.
You have about 3.5 minutes.
Thank you. Well, I have a number of disagreements with what my colleague has just represented to the court. One point is with her final point, the Ohio Administrative Code makes it very clear that in review of a case, the State Personnel Board of Review does not disaffirm any allegations that are made against an employee merely because other allegations are not successfully proved. So the fact that there were other allegations that could not be proved, and we would submit that one of the main reasons why they couldn't be proved was because we had difficulty enforcing subpoenas and locating witnesses, and it certainly wasn't because we didn't believe there was any merit to those allegations. In terms of the issue of hearsay, I would like to repeat what Ms. Grimm said. Exhibit Z was her exhibit. It was also hearsay. It was also something that was introduced for the purpose of stating that Mr. Rubens had an opinion about reports given to him about what occurred at Waterloo Oil on December 17th, 2012. And he was asked about those impressions and what his conclusion was. That entire document is relevant. She never ever, Ms. Grimm never ever requested for that document to be introduced in part. And we did not object to the introduction of that exhibit simply because it documented the details of what he had heard. In addition, as far as Ms. Grimm's claim that the Common Pleas Court review was complete and missed no detail, I need to reiterate again that key circumstantial evidence that is at the foot of the district's case right now involves the fact that there was a reported incident in late December 2012 that came to the district's attention in January. A conversation was had. There is no dispute in the evidence that this conversation was had between management and Mr. Eckert about this report, and he did mention that he referred to certain station owners as foreign owned throughout that conversation. After that, he was instructed not to use that language. But less than a month later, on a ride around with a completely neutral individual from Akron Children's Hospital, we get an additional report that he is making comments that are racially charged and completely inappropriate in a professional environment, and to think that he did this in the presence of a stranger. Now, even Mr. Eckert doesn't deny that he made inappropriate comments. He says that he was parroting what someone else told him. But even if you believe his story, which we submit we find difficult to believe, he still was making comments that he was not supposed to make. None of this evidence was considered by the Common Pleas Court and is quite incredible in the fact that it is missing from that decision. So considering the fact that there is such a detailed analysis as Ms. Grimm claims, there are, as I mentioned in my brief, a number of very interesting points that the Common Pleas Court glosses over. And they seem to have a very similar tone to the things that Ms. Grimm glossed over in her brief. Thank you.
Thank you. Thank you, counsel, for presenting your arguments to the court. The court will take the matter under advisement and issue a written opinion that will be sent to both sides and also will release on our website. Enjoy the rest of your